Good afternoon, good evening, good morning for all of you, and welcome to the ELI webinar series on the Conference on the Future of Europe. We are delighted to have this seminar today on the artificial intelligence and public administration, developing impact assessment and public participation in the digital economy. Let me please very briefly introduce ELI, what is the European Law Institute, why we organize this event, and I will immediately introduce very briefly our three co-reporters today that I'm so happy to share the panel with them. As you probably know, European Law Institute is an independent non-profit organization founded in June 2011 with the purposes of initiating, conducting, and facilitating research, making recommendation, and providing practical guidance in the field of European law development. Among the ELI task core are, for instance, evaluate and stimulate the development of the European Union law and legal policy, to identify and analyze different legal development areas related to the development of the European law, to study our approaches in the different member states, to conduct and facilitate pan-European network, to promote the role of the European Union law at an international level, and to provide a forum for discussion and cooperation of jurists. As you also know very well, this event is organized as a contribution to the Conference on the Future of Europe. This Conference on the Future of Europe is a platform for the citizens to contribute, to discuss, to the debate about the future of Europe. In particular, this event is about one of the projects that the European Law Institute is organizing at the moment. Artificial intelligence and public administration, that belongs one of the pillars of the ELI, the European Law Institute, the law environment for the digital age. Let me please introduce the three co-reporters. We have with us today Marc Clément, Jens-Peter Schneider, and Paul Craig. Marc Clément is a presiding judge at the Administrative Tribunal of Lyon. Since 2014, he has been a member of the French Environmental Authority. Since 2015, a member of the Deontological Committee of the French Institute of Radio Protection and Nuclear Safety. And he has been member of the Aarhus Convention Compliance Committee. Paul Craig, Emeritus Professor of English Law in John's College in Oxford, an honorary QZ, with a variety of research interests in constitutional law, administrative law, European Union law, and a long and intense publication track, including, for example, a history on administrative law in the United Kingdom. And he was the United Kingdom Alternative Member of the Venice Commission from 2010 to 2019. Jens-Peter Schneider is Professor of Public Law at Freiburg University in Germany. He served as a project reporter of the collaborative project on EU administrative law towards restatement and practices guide and European Union administrative procedure law. We have an extraordinary panels. They are the co-reporters in this project at the European Union Law, the European Law Institute. And I would like to give you some instruction how we are going to proceed in the seminar today. So we have two kinds of questions. We could have closed questions that attendees will be given a minute or 2 minutes to provide an answer, and then we will have a discussion. But we also have the possibility of open-ended question. Participants can use, please, the Q&A in order to provide comment or to raise question. I would like to give the floor to the co-reporters, please, so they can explain the project and the main issues that we are going to discuss today. Thank you, Jens-Peter, Paul, and Mark. The floor is yours.
Teresa, thank you very much for that kind introduction, both about ELI and the nature of the issue which this particular panel is dealing with. So let me just put it in perspective in really stark terms. So administration of one kind or another has existed since time immemorial, and with administration developed over time administrative law as well. And the kinds of people who exercised administrative authority changed over time, and they varied between different countries. But in one form or another, the exercise of administration was often conducted either by a minister or a government agency or a commission or a tribunal or somebody of that nature. So the particular types of body which exercised administrative authority varied across different countries, and the names given to them varied. But there was one very, very foundational and simple commonality. And the foundational and simple commonality was a human being made the decision. The human being might have been the head of an agency, might have been a minister, but there was a bureaucrat of some kind that made the decision. And it was traceable to that bureaucrat or the particular organization. Now, what has happened with the advance of technology over recent years is that increasingly decisions are not made by an identifiable individual. They are made either wholly or partially by an algorithm or some form of automated decision making. And this poses very significant problems or issues for all legal and political and social systems. Now, of course, an individual of some kind will be involved in designing the initial algorithm or automated decision-making system. But even then, the role of the individual may be limited, because technology is such that with some automated decision-making systems, they can indeed learn by doing, and they are not static, they are dynamic. This then raises a whole series of issues about accountability and about responsibility for the decisions which are made. And this is not surprisingly, given the range of areas where algorithms or automated decision-making are used, it's not surprising that a whole range of different institutions and bodies are involved in thinking about the best way of dealing with this. The European Union has initiatives, so does the Council of Europe, and there are studies by academic institutions in different states. Our ELI panel has developed, and we are at the final stages of developing, a set of model rules which have at their heart the idea of an impact assessment. And the essential idea is as follows. We start off from the premise that one size can't fit all. The variety and heterogeneity of different forms of automated decision-making precludes one size fits all. So basically in our model rules, we have a regime in which we have three kinds of system. We have a sort of annex one where automated decision-making is automatically regarded as high risk, and it's always subject to an impact assessment. And then with annex two, we'll have measures which are regarded as trivial and you don't need an impact assessment procedure. And then we have an in-between category where you might need an impact assessment procedure. And we then define and set out in these model rules the nature of what an impact assessment procedure is designed to do and the types of risk that it's designed to identify. Now, time is short, so just to say that in addition to that basic schema, we also have within our model rules a distinctive and extra set of procedures for algorithmic decision-making or automated decision-making, which is regarded as high risk. In those instances, we have extra procedures in terms of expert scrutiny bodies and public participation, which goes beyond what happens in the normal circumstances. So let me stop there, and we're very happy to answer questions in due course. Let me stop there and pass over to Mark and Jens Peter. Thank you.
Yes, thanks a lot, Paul. I will just briefly propose you some example of existing system. Katja, if you could, yes, okay. On this slide, I've just taken some examples from what is available on the web related to systems that were in place or are in place, just to explain that what we are talking about is not science fiction. It is things happening concretely today in various EU member states. This is not an exhaustive list of systems that you can find, but for instance, there were a system in the Netherlands to detect social fraud, and that triggers almost automatic debt recovery. This system has created difficulties for 26,000 families in the Netherlands, and this was such a scandal that the government had to leave. In the UK, recently there were a system for downgrading automatically the A-level students, probably due to the COVID or something like that. Paul will confirm that. And that was also something that was very controversial. In Sweden, an issue, just to show a different scale of systems, where it was just a system that the municipality of a city in Sweden wanted to deal automatically with reports related to children at risk, and it was proven to be also quite problematic. A completely different domain in Spain, evaluation whether or not an inmate will be paroled. There is a system apparently in Catalonia for dealing with these evaluations. And finally, I give a more positive example among the examples I'm quoting. In Greece, the system for the risk evaluation for travelers in the context of COVID-19 aimed at reopening and facilitating the way the reopening of the economy worked. So you can see here, and with the references specifically on this site, Algorithmic, algorithmwatch.org, you'll find a lot of different examples, and you'll find examples also in the press on that. I also quoted the Fundamental Rights Agency report 2020 on this, on the rights and on the artificial intelligence and fundamental rights, where you'll find additional examples and interesting examples. So this is just to give some concrete elements and to show that this is an issue which is needed to be tackled, because many of the failures in the systems that I mentioned are also failures because of the lack of public participation, preparation of these systems, and explanations how the systems are supposed to work. And this is also a very important part of the project, of the ELI project and the model rules, to have this phase to prepare to have a study in terms of impact assessment and in terms of public participation to really explain how the systems will be incorporated into the daily work of administrations. So that's it for me. Thanks a lot.
Thank you, Paul. Thank you, Mark. Jens-Peter, would you like to participate at the moment, just presenting some main problems, or we can start discussing some of the main issues that are crystallizing in these model rules?
In order to give the audience as much more way or time to discuss the problems, we decided just to have a presentation with the two of us, or by Paul and Mark, and therefore I come back in a later minute.
Thank you very much. Indeed, the artificial intelligence and all the problems related to artificial intelligence liability and application and limits and risk is one of the core themes in the European Union agenda. But one of the most distinctive features of this project of the ELI is precisely that is looking at the use of artificial intelligence by public administration. And is trying to evaluate what is the public participation in developing the digital democracy. So in that regard, there is a very clear approach in these model rules. I think that maybe the first thing that we can do is try to identify what is the experience that our audience have in relation to artificial intelligence systems and algorithmic decision making. So I suggest that maybe we can start with a couple of questions regarding the experience that our audience have in that regard. May I please ask the Secretariat to start with some question, please? You have a minute or two to provide an answer, please. So we have some result. Half of the audience, a little bit more than half of the audience has experience with artificial intelligence system. And there is another significant part that is uncertain about their experience on artificial intelligence. In case that they have experience, more of them are 70%. They are user of artificial intelligence, lawyers, academic, probably the most significant section, and others. So maybe the question that I can ask to our panelists today is the lack of experience a problem, may raise an obstacle, the difficulties in the public participation in the use of artificial intelligence by public administration? Is the lack of experience a problem, a handicap?
Maybe I step in, as I haven't said anything before. Of course, it's always good to have experience. And for that reason, it would be wonderful to have that. On the other side, I think for public participation, it's even or as well important to raise questions. And for that reason, I think with regard to public participation, it's also very important to raise your feelings or your questions so that the authorities and other people can react on that. On the other side, and that is the reason why we decided for a two-stage process of participation, not only the public, but also by experts. So these experts, they need to have, of course, experience. Otherwise, they won't fit for this job. And for that reason, it will be a good discussion between two sides of society. That's at least my point of view on that.
Thank you. Probably another element that we can put forward is that in some cases, people is not conscious, is not aware that they are interacting with the artificial intelligence-driven system, because every day in our digital life, we have personalizing strategies, we receive recommendation, we interact with the quite sophisticated searchers and aggregators. And in most of the cases, they are based on algorithm, on artificial intelligence. So this lack of experience, or even more, this uncertainty about having or not a real experience with artificial intelligence could be more related to not perception, not a proper perception that this particular service has been created, generated, or provided or delivered by an artificial intelligence system. And maybe that could be even more unperceived if we are in the area of public services. So maybe we can now, Paul, maybe you would like to participate. Yes, please intervene.
Yeah. I mean, Teresa, I think your point's a good one and an important one. And I think going back to the slide that Mark put up there, I mean, in a sense, what happens quite often is that people suddenly become massively aware of the impact and the potency and the prevalence of automated decision-making systems when things go wrong, as it were. So when the fat hits the fan, as it were, like the A-level debacle in the UK, suddenly the very fact that all these key decisions affecting the future educational opportunities for thousands of people in the UK had been made by an algorithm. And so it's when something goes wrong in particular that people become aware that decisions which are being made, which affect them in a very pronounced way, are being made by an automated decision-making system. And then what tends to happen at that stage is that then people quite logically, as it were, or naturally start unraveling backwards and say, well, what went wrong with the design of this system? Why did it perform so badly? And then you hit one of the common features of algorithmic decision-making, which is that the input can be skewed or biased or just set up badly so that it generates dysfunctional results. And there's quite a lot of examples. If you look at a really good site like Algorithm Watch, there's really quite a lot of good examples on that site of, I mean, it's not that anyone's trying to, this isn't some sort of massive conspiracy by anyone. It's just simply that you're designing a complex system, and sometimes the variables you put into the system end up being biased in one way or another. And that's particularly a dangerous problem where the algorithmic decision-making system is one which can self-learn from its own experience. So, you know, there have been instances, for example, where you've had algorithmic decision-making about used in circumstances where the system is trying to identify dangerous or potentially dangerous people, either coming into the country or on CCTV or something like that. And you can see where this is going. Quite often it ends up having, there's a danger at any rate of it having an inbuilt or learned racial bias. So people interact with this stuff all the time, and they get to know about it in particular when it goes wrong. But also, just to be fair, a lot of times it goes right, and it can make the administration work more smoothly. So in our model rules, we are not, as it were, against algorithmic decision making.
If I may just add a very small point, I think we have not in the model rules addressed only artificial intelligence systems, but we cover also algorithmic decision making, because we think that although there are let's say more complex issues when in the domain of machine learning, where you will have less possibilities to explain how the system has developed a solution. In general, many of the issues are the same when we are facing algorithmic decisions, regardless the technology or the science that is behind that. We are facing more or less the same situation. So that's why we are covering algorithmic decision-making systems.
Thank you, Mark. That is very important, because probably later when we will talk about the risk, as Paul was explaining, the risk and the perception of the risk materialize when something goes wrong. And we have to figure out what was the problem, what was the cause. It was a problem related to the design, to the data, to the self-learning. It is true that in case of artificial intelligence system, all the features of artificial intelligence aggravate and render more difficult to solve all these problems because of the complexity, of the opacity, of the lack of explainability. So indeed, artificial intelligence is based on the problems of algorithmic decision making, but in a way aggravate or definitely create additional problems related to the specific characteristic of artificial intelligence. I am wondering whether the experience of our audience and their expectation about the use of artificial intelligence would be different if we ask them about experience of artificial intelligence in the public administration. So maybe we can ask that question to the audience. Do they have experience in artificial intelligence used and applied by public authorities? Indeed, the experience of our audience decreased a little bit when we talk about public authorities using artificial intelligence, and indeed increased very explicitly the negative or lack of experience in this case to 36%. And as we can see, is citizens, lawyer, academic, or a general category of other, where we can see our audience experience in relation to artificial intelligence in the public administration. Why is that? Why do you think that this perception of the use of artificial intelligence by public administration is diminished in a way, is because public administration is more reluctant to use artificial intelligence? Is a lack of innovation in public administration? Or is again a lack of perception by citizens? Or is maybe because there are values, there are right and interest to protect by public authorities that could be put at risk by artificial intelligence, and because of that, there is a caution in order to apply this technology to public services. So do you think it's a problem of lack of innovation, lack of resources? It's a problem of more values and interest to protect? Do you have an idea about that? Do you have a perception about that?
Maybe I start. There's been a very good study by colleagues from the US, and they made a survey throughout the federal agencies of the United States of America. And they learned that many of the agencies use AI, but many of those use very basic AI tools. And so we're certainly not at the front of the process. These are private companies. Some of us are just using the internet, and we all know these companies are on the internet, and they are the big players in this regard, and it's not the public authorities. But nevertheless, the process is starting. And the second point might be that probably the interaction or the use of AI within the European member states will be very diverse. And so people from the Baltic states will have a much higher rate of experience with such instruments, or from the Netherlands, than, for instance, people from Germany, where I'm living. So that's my point in here.
Thank you. We have a question about the scope that I'm going to read. There is a question about the scope of the model rules in relation to the Artificial Intelligence Act at the European Union level. The question is the Artificial Intelligence Act at the current proposed draft is including algorithmic decision-making as a simple algorithmic decision-making, not necessarily integrating artificial intelligence technique? So this is a question that we have received from the audience, and because it's related to the scope, and Mark, you have previously explained that the idea of the model rules has been to include both artificial intelligence and algorithmic decision making, I think that we may discuss, if you agree, a little bit more about it, if you think that has been a discussion within the group when deciding how to define the scope of the model rules. I raised the question in case that you would like to deal with it now, or maybe we can postpone.
Well, maybe a few words, but then Paul and Jens Peter will complete. I think that if we would apply a technology-driven approach, it's always complicated to define what is really machine learning, what are rule-based systems, or in general, it's not really the issue which is at stake. I think the risk approach, which is not driven by technology, but by the potential risk associated to the development of the algorithm, is much more fruitful approach than an approach where you would define some technologies which are to be scrutinized and not others, and with the risk of missing the target, especially in a field where the technology moves and evolves very rapidly, and then the legislation is always 2 or 3 steps behind the evolution of the technology.
Thank you, Mark. it's a very good point, because indeed the audience is raising question about precisely the terminology, the concept, and indeed the approach to the scope. As you explained, if we define the scope on the basis of risk created by this technology, we don't have this technological problem of defining what is AI, what are the techniques that could be integrated with the concept of AI, what is the algorithmic decision making, and what should be included or excluded. That depend of this risk-based approach that the model rules have adopted. There is another question that maybe you would like to address now, or we could postpone when talking about benefits and risk. But the question is, to which extent we can address all the risk raised by artificial intelligence with a guarantee of human intervention rights. So the right of the citizen to request human intervention anytime, where there is an algorithmic or AI-driven system or decision-making. So do you think that this element, the human intervention, is key in the relationship between the citizen and the public authority?
If I may take a start, the first point for our model rules is important. We are not setting standards. We are imposing a procedure in order to learn about risks, potential benefits, and to make the best out of it. But we also ask in this procedure to set up a report, and this report shall cover various options to minimize the risk. And this point you mentioned, or the discussant mentioned, concerning the human interaction and the right to ask for a human decision making, is one key element of these measures to minimize the risk. It may be not the only one, it may be not the very best one, but at least it's one option here. And then it's up to the various legal orders in order to say this is either an obligation or whether this is more or less in the discretion of the authorities.
Just to add to what JP had said, I mean, the point about human intervention is an important one, though it also, as JP said, to some extent takes us beyond the scope of our model rules as such. So let me just put a further dimension to the human intervention point. And I think it's this, and the answer to this inquiry may vary as between different legal systems, but the point can be put quite starkly. So imagine that you've got some form of automated decision-making system operating in a particular area. And let's suppose that automated decision-making system is literally making the decision, and that it's making the decision without any particular possibility for a hearing or some sort of intervention right or a day in court or anything equivalent thereto from the individual affected. Now, whether that's indeed lawful or not is going to depend to some large extent on the public law system, administrative law system of the particular member state. So a key question that would be asked, certainly in my country in those circumstances, and the answer may be different in France or Germany, I'm not saying it would be, but the way we would pose that question in those circumstances is this: we'd say, the decision-making, the automated decision-making was made pursuant in most instances to some form of statutory authority. You'll trace it back and you'll get some sort of statutory authority to exercise power over topic X. And topic X may be any of the things set out on Mark's slide earlier. So then the next question you'd ask is, other things being equal, according to the administrative law of your country, would you normally have a right to a hearing or to be heard in some form, whether written or oral, before a decision on topic X was made. And every legal system would have rules of administrative law which address precisely that issue. So you then say, well, if normally, in accordance with the normal rules of administrative law of your country, you would have a right to intervention in that sense, a right to be heard, for example, before a decision on topic X was made. Was it then lawful for the public administration to introduce a system of automated decision-making which allowed decisions to be made on topic X without that right to be heard? And that would then be for the courts of that country to decide in the light of the relevant empowering legislation, and there'll always be some background legislation. And if the courts then decide that actually the right to be heard in this context is really important because there's an important right or interest which is at stake, which triggers a right to be heard, then that right to be heard cannot be pushed off the edge of the cliff, as it were, merely because the public administration decide to opt for some form of automated decision-making. And I think these kinds of questions about human intervention and human agency in the context of automated decision-making are going to come in some shape, manner, or form increasingly before courts of all countries, because this is an endemic problem which is not going to go away, and it's a problem of some magnitude.
Thank you, Paul. Our audience is indeed approaching to the core of our discussion. They are asking about risk, what kind of risk, but at the same time, they are identifying some benefits. They are talking about the possibility of depoliticizing the decision of the administrative public administration. They're talking about the possibility of reinforcing the democratic values, for example. But there is a very interesting question that put forward the following main issue. To which extent using artificial intelligence as a tool in the public administration decision is different? So what is different in using artificial intelligence in public administration or public authorities decision? So maybe what we can do is, why don't we ask the audience about what are the main risks that the use of artificial intelligence by public authorities raise? There, let's talk about the benefits and try to identify then what are the challenges that artificial intelligence may pose in the public authorities' normal course of action, and what are the measures, but because this is indeed the main contribution of the model rules, what are the measures that can be adopted in order to mitigate this potential risk and reinforce the benefit that artificial intelligence may provide to the public administration activity. So organizing the next discussion around these ideas, we may ask the audience what are the risks that they consider more relevant Okay, dear panelists, we have here the answer, the replies. Discrimination is a big concern, followed by the right to privacy, non-transparency and non-explainability, some concern and worries about cybersecurity, and over-reliance of members of staff of public authorities. I can see also in the open-ended comment, biased output and lack of accessibility or availability of technologies by citizens. So discrimination and biased output seems to be a great concern by citizens when dealing with public authorities that use artificial intelligence. Maybe would you like to elaborate a little bit on these ideas, the audience and the panelists? Why discrimination? What are the risks of discrimination? If Mark, JP or Paul, would you like to add anything, or happy also to get some feedback from the audience on that regard?
Well, I mean, let me just say a word, and then I'm sure Mark and JP will come in as well. I mean, I'm not at all surprised that this was one of the key concerns that participants in this webinar felt about the use of AI. And I think that's partly because, I mean, I think there are kind of two variables which feed in here. I think both of them are interesting. On the one hand, we are more aware of the dangers of discrimination in public decision-making now than perhaps we were a generation ago. And secondly, and relatedly, the range of what constitutes discrimination has become more complex, and rightly so. I mean, a generation ago, people did not talk about LGBT rights or discrimination against transgender people. I mean, they just didn't. It wasn't on the agenda. It is now on the agenda, rightly so, and that then becomes another form of discrimination which can be impacted adversely by a form of automated decision-making. So I don't find it surprising that this is one up there towards the top of the list concerning artificial automated decision-making. And if you think about those two variables that I just put on the table, what that means is that when you or whoever it is doing the initial design of the automated decision-making system, making sure that it is as fit for purpose as possible and thinking through the way in which, the various ways in which it might potentially discriminate, whether age, gender, sexuality, religion, whatever else, is a big problem. And if I could just add one further point here, then I'll stop. I think one of the reasons why this problem becomes exacerbated or more difficult to deal with is that there's quite often a disjunction between the tech people who are doing the actual building of the algorithmic model or the automated decision-making and the policy people on the other hand. When you look at the regulatory literature about this, and when there's talk about opacity in automated decision-making systems, that's often because of this disjunction between the tech people on the one hand and the policymakers on the other. And the policymakers aren't really capable, even if they know what they want to avoid, they don't always have the technical wherewithal to communicate that very effectively to the tech people, or to test whether the tech people have adequately taken that into account. And I think all of that is part of the explanation about why this is a problem.
Thank you, Paul. JP, I would like to give you the floor, but there is a comment in the audience, for the audience, that completely read my mind. Is precisely that all these factors seems to be, all of them, interrelated, because I find a very, very clear connection between discrimination and lack of transparency. And the question that one of the members of the audience raised is, how can citizens that are deprived of their right because they don't understand, they are completely unaware of the criteria according to which these decisions are adopted, and therefore they are in a very, very unprivileged position in order to identify that they are discriminated, they are biased, or simply they are refused from a specific service. So in relation to all these factors all together, what is the opinion of the panelists? Please, JP first, if you would like just to discuss the previous question, and then I give the floor to Paul and Mark about this general idea of all the factors are correlated. Please, JP.
Yeah, thank you. I think that's a very important point you and the discussion made, because this non-transparency gives this idea that there may be something happening in the background, and there may be such sort of discrimination. And in many events, there is such discrimination, especially if we have self-learning systems who learn from the recent state of play. And as we have a lot of discrimination already in our systems, man-made discrimination, then these systems may reflect that type of discrimination. On the other side, it may be that these systems are a little bit easier or more easy to be monitored, and we can test them. And I think that's an important point, that it's important to have this sort of testing against all these types of discrimination. Of course, there will be always something we will not detect, but in many cases, it will be more easy to detect such discrimination than with regard to human-made decision-making, and it's easier to adapt the system to that. At least there's some hope for it. And so another point you mentioned, that for many, I would say, ordinary people like me, who are not really aware about the all these technical stuff behind that, but that is why we have this two-step approach with the expert bodies first, and then the public participation has the chance to learn from the experts a little bit. And of course, public participation is not only by single persons, it's also by NGOs and people who are really aware in the field and who have a special focus on such problems. So that's my point.
Thank you. Mark, please.
Maybe on the risk, to highlight one thing, potential over-reliance on the tools. What we see, for instance, in the example I gave on the Spanish case, is that it is said that the decision is finally taken by somebody, a civil servant, but the fact is that if you have an evaluation of an inmate which is produced by a tool where you have coefficients, numbers, features, then it has a very, very strong capacity to show and to convince that you have to follow that. And it's very difficult to deviate from these systems, specifically when you have evaluations that look very, very scientific, and then of course the risk is also to have decisions taken formally by persons, but in fact are completely made by machines. And this is something that is also a risk that is very important. That was highlighted also in the list, but I think I wanted to stress that as well.
I would like now to change completely the side of the slow, sometimes inefficient, be a poor performance. But however, now we have the opportunity to apply artificial intelligence and algorithm to public administration activity and enhance the efficiency, the effectiveness, the capacity of allocating resources in a very quick way. So maybe we can discuss a little bit more about benefit to have a balance that gives us more clear image of what are the real challenges that we have. If you agree, let's ask the audience about benefits. With this question, please. So our audience thinks that the most clear benefit of using AI by public administration is clearly the rapidity, so faster decision making, followed by, curiously, increased equal treatment of similar cases. So in a way, it's a benefit that seems to be compensating, let's say, or countering the idea of the risk of discrimination. Even better decision, what is really interesting, that the quality of the decision may be increased, may be enhanced by the use of artificial intelligence. So we clearly have elements that lead us to the idea that AI means efficiency in public administration as well. Do you agree with that? Mark, JP, Paul?
So, sorry, let me just move this down. Thank you. That's very interesting. And again, actually, I'm not surprised by those results. It seems to me, if I had to predict in advance which would be the two boxes which would have the most hits, as it were, I would have predicted faster decision-making and more equal treatment. And the faster decision-making is in some ways self-evident, that particularly where you have public administration dealing with a very large number of rather similar claims, then doing this in an automated way, if you can set it up in an automated way, rather than through individualized decision-making, is going to be better and faster. Equally, I'm not surprised, and none of us on the panel are, about the idea that there can be a benefit in terms of enhanced equality, because, of course, we should remember that one of the fundamentals is treat like cases alike, and the trouble is that if you have human agency doing something, then you can sometimes get what we sometimes call in our country a postcode lottery, that if it is, an official in Oxfordshire makes the decision, it may more likely come out one way, and if an official in Cambridgeshire makes a decision on the same issue, then the percentage of successful cases comes out rather differently, with no particular objective rationale for that. So I'm not surprised that there's a benefit or people perceive there to be a benefit in terms of equality, and I think the benefit is a real benefit. The one thing I'd say, however, is that the benefit, certainly in terms of enhanced equality, will be more likely to feature the more mechanistic the issue to be decided is. In other words, the more routinized the issue is, the easier it is to deal with that issue in an automated way. And I think the reverse side of that coin is that when you get issues which are more polycentric or which involve inherently greater discretion or more variables, then I think it becomes more difficult to design an automated system which adequately takes account of that spectrum of relevant interests. But certainly there's a lot of stuff that public administration does, which is pretty routinized and mechanistic. And in those circumstances, the benefits of speed and the benefits which come from an enhanced equality by reducing human agency, I think are real benefits. I agree.
Thank you, Paul. Mark, I saw that you would like to reply as well, please.
No, just to say that it is very true that there are benefits, there are potential benefits, and the point is to find a way to minimize the risk for getting the very best of the technology and really to see where the technology can improve the situation. The fact that the equal treatment issue is an issue that was really raised in many cases. For instance, the Compass tool in the US, which is trying to evaluate the risk of recidivism by criminals, was asked to be developed by lawyers and others just to avoid some kind of bias by potential evaluators, which will be based on their own experience and not really take things with sufficient objectivity. So this is really an issue, but at the same time, the tools, when they are developed, as it was said previously, are developed on the basis of the experience of human beings taking decision, and the bias are in this experience and can be copied in the way the tools are designed.
I would actually highlight one point which hasn't been mentioned by, or which hasn't been ticked by so many. Europe is an aging continent, and for that reason, I think we need some support by others, be it either people from the outside or be it by tech. And especially as Paul mentioned, tech is very good in more or less standard procedures. And if we can share, or if we can use people more in the fields where we really need the flexibility and the empathy of human beings, then it's, I think, also a very important point. And we have to face this problem. We are getting older, every one of us.
Thank you very much. So acknowledging that there are benefits, there are clear benefits, but at the same time, there are challenges. There are also risks. Probably we have to focus on identifying and proposing and implementing these risk mitigating measures. And that is precisely the main core of the model rules that we are preparing at the ELI. So to identify certain measures that could be effectively mitigate the risk without compromising the benefits of artificial intelligence system in the public administration. So probably before continuing with this fascinating debate and asking other questions that we have from the audience, maybe we can ask the audience about what kind of measures could be effectively implemented in order to mitigate the risk. So dear panelists, we have a very clear support of impact assessment by public authorities, followed by independent expert participation and judicial review, definitely combined with strict liability, oversight powers, monitoring duties. So in a way, a combination of measures, but it's very interesting, and I will give you the floor immediately. It is very interesting that the audience does also identify impact assessment as a key measure to mitigate the risk. So may I please give you the floor to elaborate on the value of the impact assessment and the role of impact assessment in the model rules, please.
JP, I think you should, I mean, you're very well placed. I mean, and not any of us could do it, but I think you are particularly well placed, perhaps to elaborate a little bit more on the core idea of how impact assessment works in Article 6 of our model rules. I mean, I think it might be helpful to explicate a little bit more about that and the questionnaires which back them up.
Okay, thank you. So first of all, we are extremely happy to have convinced you to some extent, at least, that this endeavor of us is helpful. And the other good point is that you not highlight only one thing, but many of these measures, because we included a lot of them into our Article 6, which is an article who is obliging the implementing authority to set up or to draft a report. And this report has first to, of course, elaborate about what type of system will be implemented, what will be the objectives who are supported by this or which shall be implemented by this system, then about the risk, and then about the risk mitigation measures. And there will be not one size fits all. For some systems, certain points are more important than others. And so, for instance, not so many of you tick, for instance, the box for human in the loop. In some cases, it may be important, in others not. And I think you're quite correct that this is certainly not the only or the trump point to do so, because in many cases, we have a good idea why we use AI instead of human beings. And for that reason, it wouldn't make sense to duplicate the system. And this report is first a type of self-reflection by this implementing authority. to really think about, is this really needed? And if it's needed, which is the best setup to implement this in order to minimize the risk and exploit all the potentials? And then something you highlighted as well very much has been that there needs to be, of course, a discussion with other people, because if you try to implement something, you are to some extent biased. As I'm biased with regard to impact assessments, implementing authorities will be biased concerning the use of such AI tools they're going to implement. And for that reason, it's extremely important to have external monitorings on that, first by experts, and second also by the public. And I think the public is extremely important because this gives a broader view on a lot of things. And many of us, you have heard at the beginning that Mark is very strong in the environmental field. I wrote my doctoral thesis about environmental impact assessment, and we learned that this type of impact assessment is extremely important in order to support certain ideas in the field of environment, to be more environmental friendly, and with regard to AI, to mitigate those risks. I think that should help.
Thank you, JP. It's also very interesting to see how the audience noted that the reliance in the court review is also very high. So that is also important to see how this institutional framework that also create the confidence on a good monitoring and a proper oversight of the AI in the public authorities. But at the same time, many questions from the audience is related to or is based on the assumption public authority is not the same that private actors. They have different goals, different interests, different risk involved. So there are different. And when we talk about public administration, there are specific challenges that we have to deal with. Could be related to lack of expertise, lack of experience, the more relevance of specific values. So maybe in order to start wrapping out and concluding our discussion, we can ask the audience what are the challenges they consider more relevant for the AI in the next question, please. Scarcity of human resources, scarcity of hardware resources, lack of expertise in AI, and quite closely, dependence on non-European companies and lack of data as a result of data protection rules. So quite a varied concern about the challenges that the public administration has to face trying to produce a trustworthy and reliable AI. Could you please give us your opinion on that before starting concluding with our discussion today? So please, dear panelists.
So just a thought on that. I mean, again, I mean, very interesting, the kind of feedback we're getting. And again, I'm not at all surprised by that percentage breakdown in the answers given to the questions. I think the one substantive input I would make is that for me, one of the greatest challenges is something that we touched on in earlier discussion. It's the disjunction between, it's not just lack of human resources within public administration. I think it's the disjunction between the people who know the tech and the people doing the policy. Let me just give a brief, imperfect, but nonetheless analogy from a more recent event. When we had the financial crisis was both a sovereign debt crisis and a banking crisis. And one of the stories about the banking element of the crisis is that the people at the top of the banks didn't understand the financial instruments being produced by the real mathematical, techie people lower down in the banks who were devising all these highly leveraged financial instruments, and they didn't understand the risks involved. And with that, you had coupled a perverse system of incentives, because the people low down made money when they bet the right way, but they didn't lose money when they bet the wrong way. Not personally, they got a big bonus when things went right, and they didn't get fired necessarily when things went wrong. So what I'm saying is that if you have a system, I think a danger going forward is just making sure that the people within public administration concerned with policy delivery and deciding on the criteria which should inform policy delivery can talk to and get across what they want to the tech people, and that the tech people will understand sufficiently and be able to translate what the policymakers want into action, into an automated decision-making system which fulfills what the policymaker wants. And remember as well here that one of the problems is, I mean, the tech people will of course understand it at some level, but there may be instances where the tech person ought to push back at the policymaker and simply say, actually what you're trying to do is too complicated. I can't do that. I can't guarantee that 15 variables of the kind that you want can all be adequately put into this automated decision-making mix. So I think it's the human resources problem within public administration, but the duality of these human resources, the tech people on the one hand and the policymakers, and making sure that there's a proper dialogue between them.
Thank you, Paul. Indeed, the audience also support this idea of in certain countries, a social attitude that create or promote silos of knowledge, non-interconnected or not duly interconnected, and that creates the difficulties in understanding how to articulate from a technological point of view the legal policy that has to be promoted by that particular public administration. So seems to be indeed more than a lack of expertise, a lack of interplay among the different actors that contribute to the AI decision-making in this regard. We are close to the end on this fascinating webinar, and I would like to give the opportunity to the excellent panelists, co-reporters to wrap up, summary, or conclude in the next 5-6 minutes. If you would like just to summarize the main lesson learned from this discussion. So please, the floor is yours.
If I just may start, I think this last point is really important. And the good thing about the impact assessment procedure is that it's a procedure about communication, and it's setting up a room of communication between various actors. And so these very different perspectives can be taken on board and need to be going to be explicit and to be in the report, and the report will end something I haven't mentioned earlier. The report will end with an overall evaluation and an overall decision whether or not this system is needed, not needed, and so on and so forth. So I think this is some way of dealing with this problem. Certainly, it's only one part of the story, and we need for especially a real awareness about this problem, as we have the same at the moment in the COVID crisis. It's more or less the same situation between science on one hand side and the politics on the other side. Thank you.
If I may stress one thing, and I think it was really addressed by the participant in the conference, I think there is a close link between three aspects of these model rules. First is information on the systems. The way you develop the impact assessment is a way to get more information on the way the system will function and the risk and the benefits. Information is the first step. Then public participation is a way to extend the knowledge on the system by getting the feedbacks from the people that will be impacted by the system. And finally, as it was said by Peter Tarak, I think the court, the access to court and the possibility to challenge the implementation is also a crucial step. But everything is linked, and I think as Jens Peter stressed just before, the impact assessment is a way to collect more and force people to collect more information. And it's also a way probably to have the civil servants reflecting more on the way they will implement the tools and what are the benefits, what are the risks, and there are maybe different options, and to choose the options that are less risky in this context.
I would simply, I would just by way of conclusion endorse very much what both JP and Marcus said. One of the abiding and informing values of our model rules is very much this idea of impact assessment. And at the heart of impact assessment at the beginning is the implementing authority thinking through why it is doing what it is doing and providing an opportunity and impetus and obligation for it to self-reflect on why it's using an automated system and what the risks might be. That in itself will facilitate the dialogue within the administration between the tech people on the one hand and the policymakers on the other. And our model rules also provide, as it were, what we in England quaintly term a belt and braces job. So what we have in the model rules is then a further way to reinforce this, which is that certainly in high-risk systems which pose high risk, we have an expert independent scrutiny body which can then look in particular at the initial report of the implementing authority and evaluate it. And these are people who really do have the expertise, both in a sense, some combination of the technical expertise and the policy expertise. And they're then going to be providing a sort of external voice and say, well, look, okay, that's fine, but did you really think about this? And have you really taken this factor into account? So you have in that sense the internal dialogue within the primary implementing authority being fostered and taken further by an external body of experts. And I think that that all speaks to the thinking through of the risks and the mitigating of the risks which attend or can be attended upon automated decision-making systems.
Thank you. Definitely, it seems that impact assessment is a very important exercise for the public administration to meditate, reflect, assess, evaluate the risk, and therefore to be conscious and aware of what are the potential impact of the AI system, countering the risk, promoting or fostering the benefits, identifying the area of potential negative effect. So it's indeed an exercise of understanding and evaluating and assessing what are the risks before starting a process that could have effect different, difficult to be reverted, be reversed, or be mitigated when they have been caused. There is a lot of interest from the audience, and indeed they're asking about whether the model rules are already available and where can they be found. So please, Paul, Mark, or JP, if you would like to answer this very specific question before concluding today, please.
At the moment, they are not for sale. I'm sorry to say that. We're still in the progress, but nearly finalized. And it will be for the ELI Council and the ELI membership to vote on them. And the three of us and the other team members, and there are many other team members as well, we have to wait whether or not they will be accepted. But we do hope that they will be online on the ELI webpage, I think in early 2022, sorry.
Thank you very much. So it has been an extraordinary webinar, a debate that has been inspiring and thought-provoking. I very much appreciate the comment from the audience that give us the opportunity to raise some very important questions in relation to the use of artificial intelligence in public administration, the impact on the digital democracy, the public participation, the risk, and the benefits. I would like to conclude by saying that according to the Conference for the Future of Europe, there are some rules and instructions according to which a report is going to be drafted after this webinar and is going to be circulated among participants for consultation purposes. Once it is duly reviewed, it's going to be forwarded to the conference. So this participation today is going to be complemented by the consultation process when the report will be duly published before being forwarded to the conference. Thank you very much, Mark, Paul, Jens Peter, for this extraordinary debate. Has been 1.5 extraordinary, interesting, and thought-provoking and inspiring. Thank you very much, and we close the seminar today. Thank you.